further hearing in the appeal of oral application of Afzal and Iyieke against the Secretary of State undefined.
Mr. Vanetti.
Good morning, my lords. If it's convenient for the court, I was proposing to turn first to the issue of paragraph 276B of the immigration rules and the meaning of disregard. Yeah. We spent quite a lot of time on that yesterday, and I thought while everyone was immersed in it, certainly while I'm immersed in it, and have some prospect of holding it all in my head, it might be convenient to go straight to it. I'll then go back to the first issue, which is section 3C, and how that applies in the case of a failure to pay the immigration health charge, and then the last two issues. I suspect the first two will take up most of the morning, but I'm going to be very brief on the third and fourth issues, as indeed was my friend Mr. Chatterjee. Does that sound convenient?
Yes, it does. If I can, as it were, the matters that we're discussing amongst ourselves, on which we would particularly welcome guidance, are first of all, when we come on to the 3C point, the order, and particularly how Article 8 relates to the article to cover up, for example, Article 3 and Article 6.
Yes.
That's one point, and the other is Lord Carnwath's reasoning in Mirza, and in particular his treatment of a case as a 23-2 case rather than a 23-3 case.
I've been thinking about both of those overnight as well. Yes.
Well, it sounds as if we're thinking along, we've identified the same areas of difficulty.
Yes, that's not to say that I'll be able to find solutions or propose solutions, but I have been thinking about them as well, and I'll certainly try and assist with my submissions on both those points. Yep. Starting with paragraph 276B and the meaning of disregard. Our case is set out in our written statement of case. I'm not going to turn it up, but just for your note, it's at pages 694 to 698 of the electronic bundle, paragraphs 24 to 38 of that document. And of course the court's aware that we're considering the rules at the time of the decision in Afzal, but it's just worth being conscious of the fact that the rules have changed since then. And in particular, 276A, which sets out the definitions both of continuous residence and lawful residence, has changed. So, for example, immigration bail is no longer treated as lawful residence, and there's no longer any mention of temporary admission, which has rather fallen away as a concept. But we'll focus on the rules as they were at the material time.
Just for our notes, do we have the new rules in the bundle?
No, they're not in the bundles, but we can certainly provide them. We do that. So it might be helpful if we just look back at 276A, which is page 770, to look at those definitions. And continuous residence starts at the very end of 770. And as Milena from Mr. Chatterjee pointed out yesterday, continuous residence isn't broken by an absence for a period of 6 months or less at any one time, provided that the applicant had existing leave on their departure and return. So it's got to be lawful when they leave and lawful when they come back. And by little 5, they can't spend a total of more than 18 months absent from the United Kingdom during the period in question. So that's 18 months over the 10-year period. It's about 6 or 7 weeks a year. And just looking at the ordinary approach to residence, that is consistent with somebody being continually resident in the UK and having holidays or trips abroad to visit family or whatever. So B, which is the key one for our purposes is just below that at 771. And my lords have the point that it's an exhaustive definition of lawful residence. It's not includes little 1, 2 and 3. Lawful residence means residence which is continuous residence pursuant to existing leave to enter or remain, temporary admission, bail, or an exemption from immigration control. We turn then to 276B, which is at page 773. And again, you'll recall from yesterday that 276B sets out the requirements to be met by an applicant for indefinite leave to remain on the grounds of long residence. And there are 5 requirements. It's common ground, and all the authorities agree that subparagraphs 1 to 5 impose 5 discrete requirements. The issue in hoc and in the present cases is the interplay between the first and the 5th of those requirements. Little 1, with the A that remained after B was deleted, has had at least 10 years continuous lawful residence in the United Kingdom. And 5, the applicant must not be in the UK in breach of immigration laws, except that where paragraph 39E of the rules applies, any current period of overstaying will be disregarded. And in the second sentence, any previous period of overstaying will also be disregarded where, and then you've got A and B, within 28 days before November 2016, and 39E after 24th of November 2016. Now, I'm going to take you to hoc in a moment and look at it in some detail because it is really important on this issue, but I wonder if it'd be helpful if I could just summarise before we go to it what we say about hoc. So the first thing we say is that it's critical to bear in mind that in hoc, the appellants had all been in the United Kingdom for more than 10 years, but they had all become overstayers before the 10 years continuous lawful residence had been accrued. So on its face, they didn't comply with the requirement in little Roman 1 of 276B.
Sorry, you said had been approved.
Had been accrued, sorry,
Accrued,
I'm
I'm so
muttering.
Yes, forgive me.
So they've been here for 10 years,
Yes, yes.
Not 10 years lawfully. They'd become overstayers before the end of that 10-year period, and they remained as overstayers. What they relied on to try and satisfy requirement 1 was an interpretation of little 5, which involved 2 propositions. The first was that the disregards applied to little 1 as well as little 5. And in particular, they needed to rely on that first disregard, so the second part of the first sentence. Where paragraph 39E of these rules applies, any current period of overstaying will be disregarded. Because they were what's been termed open-ended rather than book-ended. It wasn't a previous period in between leave beforehand, a period of overstaying, and then more leave. They'd had 8.5 years, then they'd become overstayers, and they were still overstayers. So it was open-ended, it was current overstaying. So their first proposition was that that little proviso in 5, where paragraph 39E of these rules applies, any current period of overstaying will be disregarded, that applied, that should be read across to little subparagraph 1. That was their first proposition. Their second proposition was that the word disregarded should be interpreted as positively counted in their favour. In Hock, the first issue was decided against them by the majority, so the disregard for current periods of overstaying just doesn't apply in little subparagraph 1. The court held that the first sentence of 5 was self-contained. The applicant must not be in the UK in breach of immigration laws, except that where paragraph 39E of these rules applies, any current period of overstaying will be disregarded. But that the second sentence, beginning any previous period of overstaying, should have been, in fact, applied to little 1. It was a drafting error. So that was the Court of Appeal's conclusion on that first issue. They couldn't rely on that first disregard.
And the Secretary of State agrees with that, is that right?
Yes.
Yeah.
And I'll take you in a moment to the supplementary skeleton that we put in the Court of Appeal, accepting that that must be the right conclusion in the end. And I completely take my Lord Reed's point that it might be possible to read the applicant must not be in the UK in breach of immigration laws as not being directed just to the present moment, but being must never have been in the UK. But in fact, when we looked at the successive changes to the rules, and in particular one of the explanatory statements which explained the purpose of the second disregard, it all supported a construction by which it should have been applied to 1. But because that was the ratio of Hock, the first disregard didn't apply to 1, that was sufficient to dispose of the appeals, and that the interpretation of disregard was dealt with much more briefly. Lord Justice Dingemans was quite clear that disregard does not mean positively count. And Lord Justice Underhill addressed the point by reference to the Secretary of State's practice in the context of a rationality argument at paragraph 50. For what it's worth, a previous constitution of the Court of Appeal in Massam Ahmed had also held that the disregard does not positively count, as did the Court of Appeal in Afzal. So just really dealing with the suggestion that Sir Patrick Elias was an outlier or sort of rather aberrant in his approach on this. In fact, when you look at all the decisions and the reasoning, he really wasn't. I can see it might be said that you've got Hock on one side and the Immigration Appeal Tribunal, and then you've got Sir Patrick Elias, and the other members of the Court of Appeal obviously agreed with him, but actually one needs to look at it quite carefully. So could we turn, please, to Hock? You've got it starting at page 1112 of the electronic bundles. So firstly, looking at the head note.
I'm sorry, if you can give me just a moment.
Sorry, my lord.
My machine seems to have frozen.
That happened to me twice overnight, which is why I've printed off the key authorities and provisions as my safety net. I've got them here in front of me.
No, I'm afraid. Is it, I wonder, is it crucial for me to be following the text?
I think it might be helpful. Should we hand up a hard copy?
Oh, that would be very helpful if you have.
Technological problems are sorted out?
Robert, have you tried
It's
turning
page
it all off
1112.
consulting again?
Oh,
Because it happened to me yesterday.
right.
re-tab them myself just because I'm getting lost.
Just give me a moment, Mr. Vanetti. I'm going to see if I've turned this off, and I'm turning it on again, and we'll see if that does the trick. I'll see, I have it. I might have it, at least I've got it now. You got it? It's okay. Hand that back. Well, turning it off and on again seems to have done the trick. So, was it 1112?
It was 1112, my lord.
That's fine, I'm with you.
So if we can pick it up 9 lines up from the bottom, the line beginning with the words review were refused, the first full sentence beginning the first, third and fourth applicants identifies the issues, just as I've summarised them, I think, and sought permission of the Court of Appeal to appeal on the grounds that the period of overstaying since the expiry of their last leave to remain fell to be disregarded pursuant to the wording of 276b5, because the period between the expiry of their previous leave and the date of decision constituted current overstaying, and that the effect of the disregard was that the period in question fell to be treated as continuous lawful residence. So, two sort of slightly separate arguments. I'm not going to stop at it or read it out or anything, but you might find helpful in due course at page 1115, paragraphs 5 and 6, Lord Underhill helpfully and accurately, I think, summarises there how these issues arise in practice. And so, for example, in answer to one of the questions the court put to my learned friend yesterday, he notes that the application is sometimes made in anticipation of the actual anniversary. What counts is 10 years by the date of decision, not 10 years by the date of application. And he explains how He explains how Section 3C will often operate in these cases and be relied upon. But I just pause to note that. If we go on to page 1118, you'll see at paragraph 20, the key facts are set out again. I hope that reflects the way I've put it. And at 23, the Secretary of State's response that the various subparagraphs of 276b constitute self-contained requirements, and accordingly the disregard in subparagraph 5 on which the appellants rely cannot have any effect on the requirements of subparagraph 1. That was, of course, qualified by reference to the second bit of subparagraph 5. Then, if we turn to page 1119, just to note, you'll see just below the middle of that page, where paragraph 26 starts by summarising Masum Ahmed. You don't have that in the bundle, I don't think, but it was a court comprised of Lord Justices Floyd and Haddon Cave. And what they'd held in the subparagraph, I was going to say just by the bottom hole punch, but of course it won't be on the electronic version, but it's a quotation just below halfway, beginning the critical point. If my lords have that.
Yes.
The critical point is that the disregarding of current or previous short periods of overstaying for the purposes of subparagraph 5 does not convert such periods into periods of lawful leave to remain. So that's really the second issue. What does disregarded mean? Still less are such periods to be disregarded when it comes to considering whether an applicant has fulfilled the separate requirement of establishing 10 years continuous lawful residence under subparagraph 1A. So in Hock, the court found that that second proposition was wrong. In fact, it was agreed all round that that second proposition was wrong. The second proviso in 5 does apply to little 1A, the bookended any previous period of overstaying. At paragraphs, well, the analysis begins just above paragraph 29. At paragraphs 29 to 35, the court considered the language of the provisions. It is quite complex, but you've been taken to it yesterday, the division of little 5 into 3 sections, A being the primary requirement, B being the first proviso in relation to any current period of overstaying, and C being the second sentence, which relates to previous periods of overstaying. And the court concluded that on the language of the rule, the second sentence of 5 would simply not have any effect in relation to current overstaying. So the language suggested it was more appropriate as a qualification to 1. At paragraphs 36 to 37, the court considered the drafting history, and in particular, can I draw your attention at the bottom of page 1121 to paragraph 37.2. And that was the explanatory memorandum we looked at yesterday, if you remember, paragraph 7.49, which shows that the drafter regarded the changes made to subparagraph 5, which are clearly what's being referred to in the second sentence, as affecting the requirement for applicants for ILR to have completed a period of continuous lawful residence in the UK. That means that however anomalous the placing, the intention was that it should apply to the requirement under subparagraph 1A. And he set out 749 just at the end of paragraph 36, just a little bit above that. And it's quite explicit. Changes have also been made to the requirements for applicants for indefinite leave to remain to have completed a period of continuous lawful residence, which is requirement 1 in the UK. These ensure that the Secretary of State will disregard any period of overstaying between periods of leave, which at the time the further application was made fell to be disregarded under the previous 28-day period and all the exceptions identified above. This is for reasons of fairness. So the second sentence of 5 was intended to apply to 1. But none of that casts any light on the issue in this case, which is what does disregard mean? Does it mean that you ignore the break, because of course it's got to be continuous lawful residence, or does it mean that you add in that period of unlawful residence as contributing to the 10 years? Paragraph 38 is probably one we need to take relatively slowly because it's one that Mr. Chatterjee places some reliance on. And in particular, he drew attention to the last sentence. Ms. Giovanetti told us that the terms of the guidance, as one would expect, reflect the approach which the Home Office takes in practice. But the provisions of the guidance we're looking at are, again helpfully set out verbatim above, gaps in lawful residence. And the point the court was making was that those bullets are clearly intended to reflect element C in subparagraph 5. And so it's the penultimate sentence that's key to this paragraph. Clearly, the Home Office itself thought that element C qualified subparagraph 1A. And it's in that respect that Council confirmed the terms of the guidance reflect the approach the Home Office takes in practice. So you have the language which is more consistent, or it makes more sense if you apply that second proviso to subparagraph 1. You have the drafting history and the explanatory memoranda, and you have the guidance, all of which are predicated on gaps being relevant to calculating continuous lawful residence. But none of that helps with the meaning of disregard. The second paragraph that's relied upon as being some sort of a concession is paragraph 42. That's on page 1123. Although I felt it necessary to explain my reasoning in full, since I'm differing from another division of this court, in fact it was common ground before us that element C in subparagraph 5 must be treated as qualifying the requirement in subparagraph 1A. In her original skeleton argument settled by different counsel, the Secretary of State sought to uphold the reasoning in Massam Ahmed, but in a helpful supplementary skeleton, Mr. Keith and I conceded that there was force in the point that the first and second part of 276b5 are addressing different matters, and that it followed that some of the reasoning in Massam Ahmed is erroneous. That was a fair concession and correctly made, but all of that goes to, does the last sentence qualify continuous lawful residence? None of that goes to, what does disregard mean? And so if we read on to 43, we see the court agreeing with the submission. That conclusion doesn't assist the appellants because their cases don't involve a previous period of overstaying. The concession didn't extend to the effect of element B, that is, any current period of overstaying will be disregarded. And at 44, I accept that submission. So that is the ratio of the case. These were appellants who wanted to rely on the first exemption for current overstaying, and that did not apply to calculating the 10 years. Now, at this point, I think it might be helpful to turn to the supplementary skeleton argument that's been referred to. That's the supplementary skeleton in Hock. It was before the Court of Appeal, and they made quite extensive reference to it. And my learned friends also referred to it in his case, and although he didn't take you to it yesterday, I think it's one of the additional documents that he drew attention to in the overnight emails, which I presume the court has received.
Yes.
Yeah.
Yes.
So that starts at page 343. So at paragraph 3, we drew attention to MD Jamaica, which, when we come to it, you'll see the Court of Appeal in Afzal also refers to. And the proposition really in that case was the one I've already put to you, and I think it's common ground, and that's that the definitions of what is lawful residence are exhaustive. Then facts, key facts summarised at 5. Key issue summarised at 6. Again, I think all consistent with the reasoning of the court. At 7, the key submissions we made. So again, lawful residence, at 7A, page 345. Lawful residence for the purpose of 276B is defined in paragraph 276AB. So, leave, to enter or remain, temporary admission, or an exemption, and that definition is exhaustive. None of the appellants has at any point accrued 10 years lawful residence in the UK, whether continuous or otherwise. Thus, none of the appellants meets the requirement in 276b(1). The analysis starts at paragraph 8. At 9, that's elaborated. 10, in short, none of the appellants has accrued 10 years lawful residence. 11 deals with the submission that the definition of lawful residence in 276AB is not exhaustive. Points to the fact that in MD Jamaica, the Court of Appeal rejected that argument. Then noting that the appellants rely on POC to say if there's ambiguity in immigration rules, guidance can be used for assistance. At 13, POC of no assistance here. There is no genuine ambiguity. And then 14, the concession, as it's been termed. There is an area of ambiguity in 276B5, but it doesn't assist the appellants. That ambiguity relates to whether gaps in the continuity of lawful residence falling within the second part of 276B5 are to be disregarded in calculating whether an applicant has accrued 10 years lawful residence. Questions addressed below. However, the critical point is that it's of no assistance to the appellants because none of them seeks to rely on a period of overstaying between periods of leave. They were all current overstaying cases. Each was lawfully present in the UK for significantly less than 10 years, but remained and continues to remain as an overstayer. Thus, the second part of 276B5, which only relates to gaps between periods of leave, simply doesn't arise. At 15, having reviewed the evolution, explanatory memoranda, etc., Secretary of State recognises there's force to the point made by one of the appellants, Mr. Arif, etc. So all of this, I think, reflects precisely how Lord Justice Underhill put it in his judgment. And at 19, if the court's inclined to accept that analysis, it would follow that some of the reasoning in Massam Ahmed is erroneous. And then 20, of course, that is consistent, that, i.e. 5 separate requirements, second part of 276B5 provides for previous overstaying to be disregarded, is intended to apply when calculating 10 years continuous lawful residence for the purposes of paragraph 276B1. Of course, that's consistent with the approach adopted by the Secretary of State in practice. As the appellants point out, the Secretary of State's published guidance to caseworkers has long reflected that approach and expressly provides that gaps in lawful residence falling within the exceptions specified in the second part of 276B5 are not to be held against an applicant when calculating whether 10 years continuous lawful residence has been accrued. So the gaps are not held against an applicant as being breaks in lawful residence. And then the next sentence, indeed, it appears to have been the practice that where there are such gaps, i.e. periods of overstaying between periods of lawful leave, the Secretary of State has been more generous than required by the language of the rules and has included them as counting towards the 10 years lawful residence. And as the Court of Appeal in Afzal pointed out, firstly, that's put fairly tentatively, it appears to have been the practice. Secondly, it's not saying that's how the Secretary of State interprets the rules. It says in terms that it's more generous than required by the language of the rules and has included them. And a great deal of weight has been put on this practice. But it is put very tentatively, and it was put very tentatively on instructions because, as you'll be aware, this skeleton argument, supplementary skeleton, was put in very shortly before the hearing. We'd tried to get some instructions as to what decision makers were actually doing. Those instructing us had identified some examples where it appeared that the breaks had been counted. But we equally know there are examples where they weren't counted, Mr. Afzal being one of them. And the appellant before the upper tribunal, in the case whose name I've forgotten for a moment, the decision of upper tribunal Judge Bloom, Munib Asif. I think it's Munib Asif being another one. But we felt it was right to tell the court that simply as really a matter of candour, to make sure that they were aware of the fact that we had come across decisions where a different approach had been applied by individual decision makers. So if we could turn back to Hock, please, to the final paragraph that's really relied upon by the appellants.
Could we have the page number again?
Oh, I'm so sorry. It's paragraph 50, which is at page 1124. So I think we last left it at 1123. We looked at paragraph 42 and 43.
Yes, thank you.
I'm so sorry, just before we go to 50, it's also probably helpful to look at 45, where Lord Justice Underhill identifies where he says the court went wrong in Masum Ahmed. And that's that it treated the situations covered by the two cases, that is, open-ended and book-ended, as if they were the same. So they treated current overstaying and previous periods of overstaying as if they were the same, and that neither of them could go to little one. Quite agree that's a natural starting point, as was observed yesterday, but on the arguments before us, I don't think it can be the end of the analysis. And we say all of that is difficult and complicated, and made more complicated. I mean, that's the reason the difficulty arose was because of a drafting error. But it's an absolutely accurate analysis that we would endorse. If we turn then to paragraph 50 on the next page, 1124, having rejected the appellant's key submission, Lord Justice Underhill goes on to say that's not a complete answer. Mr. Biggs submitted that the unavailability of a paragraph 39E disregard for the purpose of satisfying the requirement of continuous lawful residence was irrational or a disproportionate interference with an applicant's Article 8 rights. So it's a slightly different argument. And it's in that context that Lord Justice Underhill said, a few lines further down the line, beginning the words, be necessary. If he's right about that, it might be necessary to give a strained construction to the rule. I should therefore also say that I do not regard it as unreasonable or disproportionate for the Secretary of State to treat book-ended and open-ended overstaying differently. It explains why. It's in those circumstances unsurprising that the Secretary of State should think it right to allow the period between the expiry of the previous leave and the grant of the further leave to count as continuous lawful residence. When you look at the supplementary skeleton, it seems fairly clear that that's got to be a reference to the last sentence that we looked at. It appears to have been the practice because there was no suggestion anywhere that the Secretary of State interpreted the rules as requiring disregards to be counted. I go so far as to accept that paragraph 50 might not be altogether clear, and I intend absolutely no disrespect to Lord Justice Underhill. It's often difficult when you're dealing with four appellants who are running four slightly different arguments and you're trying to cover all of them. It's not entirely clear there whether he is dealing with the rules or the irrationality argument, but I think on balance a better approach is to say he was looking at the specific argument in reliance on the practice. And I'm reinforced in that by the approach taken by Lord Justice Dingemans.
So just before we leave that, so at this point, we're into obiter dicta.
We are. That was going to be my next point. My Lord's absolutely right.
Yeah, so this is the book-ended scenario.
Yeah.
And Lord Justice Underhill is saying that he could understand why there is a potential difference in approach,
yeah.
And he here sets it out. It's a sort of, as a matter of policy,
yeah.
One could understand why one would treat them differently.
Yes, I think that's right. I think I'd say practice rather than policy, but yes, yeah. You can understand the practice that some decision makers may have adopted. When we move on to Lord Justice Dingemans at page 1133, he starts at 97 by agreeing with the judgment of Lord Justice Underhill, and in particular with his construction of paragraph 276b5. So he's not proceeding on the basis that he's differing from him. He then summarises his reasons for that, including his reasons for disagreeing with Lord Justice McComb. And then at the end of paragraph 102, he says...
Just before we get to that, it's interesting, well, perhaps relevant at 98. He says it's common ground that the rules are to be interpreted according to the natural and ordinary meaning of the words used. That was common ground there. I don't know if it is here, but it's a pointer towards giving the words, the language of the rules, its ordinary meaning, rather than giving it a technical or artificial meaning.
Yes. I would expect it to be common ground here as well, because I think it derives from some dicta of Lord Simon Brown in this court. Yeah. And I would certainly say that's absolutely right. Then at the end of paragraph 102, the final sentence, beginning at the end of the fourth line up from the bottom, further, and this is again the sort of the secondary argument, so more or less this is pretty much obiter, but even if the current period of overstaying is disregarded for the purposes of paragraph 276b1, there is nothing which converts that period of overstaying into lawful residence, as defined in paragraph 276ab. And that's almost exactly the language that was used by the Court of Appeal in Massam Ahmed, Lord Justices Floyd and Haddon Cave, and indeed by the Court of Appeal in Afzal's case. Disregard means leave out of account or ignore. It doesn't positively count as being something which, on the plain words of the definition provision, it's not, i.e. lawful residence, which is exhaustively defined in 276A. So that's what I have to say about Hock. That's why I say it's consistent, really, with the reasoning of the court in Massam Ahmed, and indeed the decision of Mr Justice Sweeney and Junaid Ahmed. Could we then turn to the reasoning of the Court of Appeal in the present case, which starts at page 66 of the bundle.
But you would accept that the obit dicta is against you?
Well,
in a case of that we're here concerned with, which is a book-ended case.
Well, I don't accept that the obit dicta of Lord Justice Dingemans is against me. In fact, it seems to be entirely in my favour. He points out the fact that it's completely contrary to the language to treat it as counting towards, positively counting towards. And
if the meaning of the rule is that the period should be left out of account or ignored, and there's been a practice on the part of some case officers of not doing that, then they've been failing to apply the rules correctly.
Yes.
And the rules are a statutory statement of the practice to be followed by virtue of Section 3 of the 1971 Act.
Absolutely. And in that regard, I ought to draw your attention to 276 D, which explicitly says that an application for indefinite leave to remain on grounds of long residence which doesn't meet the requirements of the rules must be rejected. But what I say is that you can't treat the fact that some decision makers appear to have misunderstood the rules as meaning that must be the right interpretation. I mean, the reality is that because it's going to result in a decision that's favourable to an individual, it's never going to be appealed or challenged, and it only seems to have been picked up in the days immediately before the Court of Appeal hearing in Hock, when we asked, could you just have a look at some decisions and make sure that's what's being done in practice?
And I think you said that the practice was fragmented because we have
yes.
clearly examples of cases coming through at that time where
Yes.
The gap period was not positively counted towards the 10 years.
Well, we know that, yes, from Mr. Afzal and Mr. Asif in the upper tribunal.
And the
But
court,
we just felt it was right for the court to know that some decision makers did appear to have been counting it positively in people's favour.
yes, yes.
Sorry, just to press the point. So, if I confine myself to the obiter dicta of Lord Justice Underhill in paragraph 50, what precisely are you then saying about that?
I'm saying it's not wholly clear whether he's referring to the practice or the interpretation of the rules, but I think I would accept that on one reading of that paragraph, it's against me. Moreover, the Court of Appeal in Afzal proceeded on the basis it was against me, so they addressed it on that basis. So I certainly accept that it's arguable that it's against me.
Thank you.
So you disregard the period when deciding whether or not there is continuous period.
Yes.
It doesn't mean that you're doing anything positive there.
Precisely.
And you say it is the period which you're disregarding rather than the overstaying which you disregard.
My Lord's absolutely right, and I'm really sorry and very grateful because I had meant to make that point when we looked at the language.
Yeah.
The language of the rule is that it's the period that's
Yes.
to be disregarded. That's absolutely right. So we turn then to Afzal at page 66, if my Lords are content to move on to that now. And I was going to pick it up at page 83, paragraph 52. As my Lords are aware, the only reasoned judgment was that of Sir Patrick Elias, with Lord Justices Peter Jackson and Nailed agreeing. I'm going to pick up his reasoning at page 83, paragraph 52. So just above 52, we have the heading, can disregarded periods of overstaying count toward the 10-year requirement? At 53, Lord Justice Elias starts with the two definitions which we've looked at 276A and refers to the reasoning of Lord Justice Dyson and MD Jamaica, means rather than includes, shows those definitions meant to be exhaustive. Doesn't, of course, preclude the possibility those definitions may have been subsequently varied by later immigration rules, and 39E was, of course, passed subsequent, but where an important concept such as the relevant period of long residence is concerned, the variation would have to arise either expressly or by necessary implication. In 54, he summarises the ratio of hoc, i.e. there are two separate periods, and two separate disregards, and the second disregard, bookended period of overstaying, previous overstaying between periods of leave. In 55, he says, I'd expect the concept of periods being disregarded to have been intended to have the same meaning in both contexts, and would so treat it unless driven to a contrary conclusion. And we already know that the Court of Appeal in Hock said that it couldn't be positively counted when it was within the first disregard, and the language is the same. Any current period of overstaying will be disregarded. Then the second disregard that we're concerned with, any previous period of overstaying between periods of leave will also be disregarded. So you'd expect those two to have the same meaning. At 56, the natural meaning of a period being disregarded is simply that one shouldn't have regard to it. It should be ignored. And I don't think there was any reference to the dictionary definition, but as my Lord Reid pointed out yesterday, that is consistent with the dictionary definition. At 57 to 60, Lord Justice Elias considered the reasoning in Hock. Firstly, he referred to Wakar Ali, where Lady Justice Simler held that an application made within the 14-day grace period was not made within a period of lawful residence. And he says that's wholly inconsistent with the notion that the period of overstaying can, in the context of an open-ended period of overstaying at least, count as a period of lawful residence. And then at 59, he says that the court in Hock adopted the same approach in relation to the open-ended overstaying. And it points out at 60 that Lord Justice McComb disagreed with the majority on that point. That was inconsistent not only with the views of the majority, but also with the analysis of Lady Justice Simler and Wakar Ali at 61. And at 62, he summarises briefly the three difficulties with Lord Justice McComb's approach. And then at 63, he turns to analyse the meaning disregarded in the second sentence of 276b5, where the period of overstaying is historic and bookended by periods of leave. And he sets it out again there. And at 64 and 65, he makes the point that my Lord made to me a moment ago, which is that the obiter part of that reasoning was against me. And that's the basis on which he proceeded. I reference to paragraph 50. And in 66, he addresses that. I don't disagree that it wouldn't have been irrational for the Secretary of State to have allowed gaps in bookended periods of overstaying to count, but nor is it irrational for the Secretary of State to take the view that they should not count, and it would not be appropriate to allow periods of overstaying in breach of the immigration rules to be treated for all purposes as if they were periods of lawful residence with the same status as Section 3C periods. Well, Justice Underhill appears to have made an assumption that the only way in which the second sentence of 276b5 could qualify the concept of continuous lawful residence was by permitting the period of overstaying to count. He doesn't appear to have considered the alternative possibility that the intended impact on the calculation of 10 years residence is simply to preclude paragraph 39e periods of overstaying from breaking continuity, which was the approach that we had put forward in our supplementary skeleton, albeit very briefly, because of course we weren't concerned in that case in Hock with bookended periods, previous periods of overstaying. And he's quite right to say that Lord Justice Underhill doesn't address that interpretation, that those periods don't break, that's sort of the disregard, they don't break the continuous residence, but they don't count towards it either. At 67, he says that that approach is inconsistent with the three preliminary observations, which we've already been to. It significantly distorts the natural meaning of a period being disregarded to allow it to count. Far from disregarding it, this involves positively having regard to the period of overstaying and treating it for all the world as if it was a period of lawful residence. At 68 seconds, as Lord Justice Underhill recognised, it's giving the concept of disregarded in the context of bookended periods a wholly different meaning from that adopted with respect to open-ended periods. If this were a necessary implication, that would be justified, but in my view it's not. The concept of disregard can be given the same meaning in both cases, i.e. the period of overstaying is ignored. And thirdly, this approach rewrites the meaning of lawful residence to include periods not granted pursuant to leave in circumstances where, in my view, the extension of the definition, that's the 276A definition, is not a necessary implication arising out of the linking of the two provisions, as Lord Justice Underhill seemed to assume. Not bound by the view of the court in Hock on this point. For the reasons I've given, I'd respectfully not follow it. But I would emphasise that's just the view in paragraph 50, because that's the only bit of the reasoning that addresses it at all.
I just wanted to check, does Lord Justice McComb in Hock say anything about the disregard point?
I think he proceeds on the basis that both periods count positively in an appellant's favour.
And his reasoning for that?
I don't think I could do it justice in my oral submissions. It is long and complex. I just invite you to read the judgment on the basis it is a minority judgment. He said that the Secretary of State had changed position, that the acceptance that there were two disregards rather than one, and that one applied to 1 and one applied to 5, was fanciful, and that once you accepted that one of the disregards applied to 1, the second must apply as well. And he seems really to assume that disregard means count in favour. But the reasoning is primarily directed to why he disagreed with the view of the majority that the first sentence was self-contained of little 5, and that it was only the second sentence that had been put in the wrong place.
Yes, thank you.
The judgment then goes on to look at the guidance. Does that dictate a different construction? And there's reference to the case of Munib Asif in the upper tribunal, which my learned friend referred you to. I'm not proposing to go to it. It's an upper tribunal decision that looks at the reasoning in Hock and says it's right and we're going to follow it. I'm going to follow it. At 72, Lord Justice Sir Patrick Elias now, observes that the judge in Munib Asif, in addition to the authorities, also put weight on the version of the long residence guidance published in October 2019 in support of his conclusion that paragraph 39E periods of overstaying count. Now, of course, that's guidance that was published subsequent to... No, I'm wrong about that. Sorry, I was thinking of 2017. It's the guidance, I think, that was considered in Hock and that we looked at the 4 bullet points. I'm so sorry if I could just have a moment. I just give the paragraph reference again.
1122, paragraph 38.
Yes, thank you so much, my lord.
Yeah.
But that doesn't say that it's going to be counted either way. It just says you may grant the application if the applicant has short gaps. It doesn't say you count them in. It's equally consistent with it being that you don't treat them as breaking.
Well, they're described as gaps in lawful residence.
Yes.
You know, so in other words, periods when you're not lawfully resident.
Yeah. So, yeah. So the disregard, the previous period of overstaying and calculating 10 years continuous lawful residence, those gaps may be disregarded, so not taken as breaking the lawful residence. And Lord Justice, Sir Patrick Elias has addressed that at paragraph 73. He makes the point that it's only if there's ambiguity in the rules that you can have regard to the guidance as an aid to construction. And when properly analysed, he didn't accept there was any ambiguity. Disregarded means disregarded. But even if he was wrong about that, and there is genuine ambiguity, he wasn't persuaded that the guidance supported the proposition that that the guidance supported the proposition that 39E periods overstaying should be treated as counting towards the period of long residence. Now that's really, I think, moving into the third ground in this case, which is the guidance, and you'll have seen we've addressed that in our written case. Mr. Jafferty relies on the terms of the guidance, but he doesn't address the points that Patrick Alliance makes, that the guidance can only be relied upon as an aid to construction of the rules if the rules are ambiguous. And secondly, he didn't in his oral submissions take you to any particular provisions of the guidance that were said to demonstrate that the periods are to be positively counted as being lawful residence. In the appellant's statement of case, they say, well, the Court of Appeal says the guidance is ambiguous, but that counts against their reasoning, that that's a problem for them that the guidance is ambiguous, but it's not. You need clear guidance to qualify the meaning of an ambiguous rule, to use as an aid to construction to an ambiguous rule. So I'm sorry to have verged into ground 3, but that is our short point on ground 3, that the guidance is not a standalone point. If the rules are unambiguous, the rules must prevail.
I only discern the appellant's ambiguity to be that the second part of room numeral 5 was in the wrong place, and that certainly is ambiguous.
Oh, that certainly is.
But there's no ambiguity, you say, in the word disregard.
Exactly.
Yeah.
Exactly, my lord, yes. Those were my submissions on 276B and the meaning of disregard. And I wonder if the court had any questions or any additional points they wanted me to address on that.
Could I ask you, I mean, one of the submissions put by your opponent was that normally in immigration law, and he gave us the example, I think, of temporary admissions, you do count periods, and that this might be regarded, therefore, as a somewhat, count on lawful periods, as a somewhat unique exception to that. I just wondered what you might say about that.
Well, firstly, I'd say that temporary admission is explicitly, or was explicitly within the definition in 276A. So the immigration rules expressly provide that that's to be counted as lawful residence. That's nothing to do with the normal practice in immigration law, and I'm not quite sure what he means by that if it's not a reference back to the definition at 276A. 276A tells you what lawful residence is, and temporary admission was at the material time deemed to be lawful residence. And then, as I observed initially, it's not anymore. I mean, it's just not a concept that exists anymore because it's been replaced by the concept of immigration bail, which is no longer treated as lawful residence. But I don't know if it would help if I explained just briefly to the common circumstances in which temporary admission is granted. So it was granted when it existed, and some of the court will be familiar with this, but it was granted as an alternative to detention. So, for example, commonly, if somebody arrived in the United Kingdom without leave and applied for asylum, they wouldn't be detained pending a decision whether to grant or refuse them. They would be granted temporary admission. And then in due course, their asylum application would be decided. The decision was a refusal. They might well appeal, so it could be quite a lengthy period of stay. If it was ultimately successful, that period, when they'd been waiting for the final determination of their claim, would count as lawful residence. Temporary admission is sometimes also granted when people are challenging a decision, as happened in Mr. Iyieke's case, by judicial review. So, it's really quite a different scenario to somebody simply overstaying, allowing their period of leave to expire and staying in the UK, although they don't have permission to be here anymore, without making an application.
So I think the submission made was that what we're here talking about is a natural extension of temporary admission. I think that was the submission made.
Yes.
You would just say that's...
Well, I say that the paragraph 276A is exhaustive. It is a definition. It doesn't include periods of overstaying between periods of leave. It could have done if that's what the intention of the drafter of the rules had been. They treat it quite differently. Temporary admission is to be treated as lawful residence. Periods of overstaying between periods of leave are to be disregarded. That's what the rules provided for. In a way, it's almost a parallel to the argument that was being advanced to the Court of Appeal in Hock, that it wouldn't be irrational to include it. And I'm not suggesting it would have been irrational if the draft of the rules had wanted to include overstaying, but it's not what they did. And that's the short point.
I don't know the answer to this, and I'm just asking the question, and you may not know the answer either. But it occurs to me that if a typical situation where temporary admission is granted is that of a person a refugee who comes, or yes, if we're talking about a person who arrives in the UK, claims asylum, and the application is successful, and they are granted leave to remain, then ex hypothesi the person is a genuine refugee. I just wonder whether our obligations under the Geneva Convention, as given effect in the 1961 Act, might require us to treat the person as having been in the UK lawfully, ab initio, rather than being in the UK unlawfully and only acquiring a lawful status in the UK on the grant of leave to remain when the application succeeds.
I'm not aware of that as being an obligation. I mean, there is an obligation, as my Lord will probably be aware, not to impose penalties on people because they come to claim asylum. I don't think it goes so far as being an obligation to treat them as having been lawfully resident. And I just give that as one example. I'm not saying that is where temporary admission is granted, but it's an example. I think my key point is that the drafter of the rules thought about it and decided that that was a situation that they wanted to bring within the definition of lawful residence, whereas periods of overstaying between periods of leave, they didn't put within the definition, but they provided for them to be disregarded instead. Unless there's anything else, shall I move on to 3C? And we've proceeded faster than I was anticipating.
That's not a problem from our perspective.
Oh, good. It'll only be a problem for me when I leave and realise there were 2 key points I didn't make. But the court's been very helpful in pointing out to me the gaps in my submission, so I'm very grateful for that. So, section 3C leave. Okay, so that's addressed in our written case, pages, again, just for your note, 687 to 694, at paragraphs 5 to 20. It involves consideration of the 2015 order and of the immigration rules. We entirely agree, and I think it is common ground, that the order is legislation and takes precedence. So we would say if there's any inconsistency between the rules and the order prevails. But insofar as possible, the two should be interpreted compatibly and consistently with each other. So could we start with the immigration rules, please, which are at page 753 of your bundle, and again we're looking at the rules applicable at the time. We looked at these yesterday. I hope you'll bear with me if we go through them again. I'll try not to take up too much time with this. So, paragraph 34 of the rules is mandatory. It says that an application for leave to remain must be made in accordance with subparagraphs 1 to 10 below. And at 4, just at the bottom of page 753, you'll see when the applicant is required to pay the immigration health surcharge, this must be paid in accordance with the process set out on the visa and immigration pages of the gov.uk website. We can then turn to page 755 under the heading Invalid Applications, about a third of the way down the page. Subject to paragraph 34B, where an application for leave to remain does not meet the requirements of paragraph 34, it is invalid and will not be considered. And I pause there to make the obvious point that the rule says it is invalid, not it may be invalidated. (34B) confers an element of discretion on the Secretary of State. So when an application for leave doesn't meet the requirements of 1 to 9 of paragraph 34, the Secretary of State may notify the applicant and give them one opportunity to correct the errors or omissions identified by the Secretary of State. And you'll recall, and we'll see again when we turn to Iqbal and Mirza, that this court was rather critical is probably not the right word, but thought it was very unsatisfactory that you could have individuals in the position of the first three appellants in Iqbal and Mirza, where the fee had gone up shortly before they paid their application, and they had simply not noticed this, and they had paid the old fee. And before this provision was introduced, that application just was invalid. There was no way it could be rectified. So 34B was added after that, and it gives the Secretary of State power to notify the applicant and give them one opportunity to correct the error or omission.
Just going back to 753, what does that mean, paragraph 4? That where the applicant is required to pay, does that mean that the requirement to pay only arises if they're not exempt, and a decision is made that they are not exempt?
We'll see more when we turn to the order, because the order defines who is required to pay.
Right.
But yes.
Right. Okay.
and some people may be exempt from payment, and that's set out in Schedule 2 of the order, which I think has quite a long list of exemptions. Then 34B2, back to page 755, where subparagraph 1 applies, the errors or omissions identified must be corrected within 10 working days of the date on which the notification was sent. Subject to paragraph 34B, where an applicant doesn't comply with paragraph 34B2, the application is invalid and will not be considered. So if it doesn't meet the requirements in the first place, it's invalid. Secretary of State may give one opportunity for that to be put right. Where the applicant doesn't do that, where the Secretary of State exercises that discretion, the applicant doesn't correct the error within 10 working days, the application is invalid. Again, not may be invalidated. And at 4, the Secretary of State may exercise discretion to treat an invalid application as valid, as long as the requirements of paragraph 34, 3, 5 and 10 have been met. But as I think my Lord Sales pointed out yesterday, in the absence of a positive exercise of discretion, the application is invalid under the terms of the rules. And then 34B5.
And that doesn't apply, I think, as we pointed out yesterday, to this sort of health charge. 34.4.
Oh, you mean 34.3.5 and it's not specified?
Sorry, 34 subsection 4 is not specified.
Yes, exactly. Sorry, I wasn't quite clear what the question was, but absolutely.
Yep.
Yes, so this is a case where the Secretary of State can positively exercise discretion to treat an invalid application as valid, although there's no suggestion she did so in this case. And then 34B5, which is a key provision from a learned friend's argument, notice of invalidity will be given in writing and served in accordance with Appendix SN of these rules. And my Lord Reid, I think, very pithily summed up the key question yesterday, which is 34B5 informative or constitutive? So does it tell somebody their application is invalid, or does it constitute the rendering of the application invalid? And we say it's informative. And if you read 34A and B together, it's quite clear that the application is invalid either if it doesn't meet the requirements and no opportunity to correct the error is given.
I think one can observe that 5, because it's referring to notice of invalidity, is not referring to a case within 4 where discretion has been exercised to treat something as valid, because then you wouldn't have to give notice of invalidity.
No, exactly,
so it's giving notice of an invalidity which appears earlier on from 1 to 3.
Yes, absolutely, that's absolutely correct.
Just going through from page 754, paragraph 4, the applicant in this case wasn't required to pay the immigration health surcharge because there was an exemption application.
Well, yes, it's a little bit complicated. Can we turn to the order and then turn to the explanation of the facts when we get to the judgment in Afzal? But in short, what happened was that the applicant applied for a fee waiver. At the time, an application for a fee waiver was treated both as an application to waive the fee and to waive the surcharge. It wasn't granted. He was then required to pay. The Secretary of State gave the one opportunity, which accords both with the order and with 34B2, so they're consistent in this regard, and allowed 10 working days.
Secretary of State did that twice.
Yes. Not sure where the power came from to do it the second time.
Well, is the date of deemed invalidity invalidity, therefore the earlier date in November as opposed to the 22nd of November? I mean, how can you extend an invalid, if your argument is correct? How can there be an extension if the application is invalid?
Well, it doesn't help the appellant. I think the Court of Appeal adopted the most generous interpretation, and maybe there'd be an argument of estoppel or something if the Secretary of State purports to give you another 10 days, even if the rules don't authorise that. It would be possibly unlawful for her then to say your application was invalid during the period when I'd said I'd give you another 10 days. I mean, the Court of Appeal didn't reason it out that way. They simply recorded the fact that a second opportunity was given and said they'd take the expiry of that second opportunity as the date of invalidity. But I think for my purposes, it doesn't matter really. Strictly speaking, it was probably the expiry of the first period, because we'll turn to the order in a moment, but the rules and the order provide for an opportunity, not for multiple opportunities.
We're going to come on to the order, I know, but there was some discussion yesterday about how Rule 34B4 would sit with Article 6 of the order, which seems to be a mandatory term. So you're going to help us
I'm
with
going to go to that now, my Lord.
Right.
Yes,
Well,
right.
before you do so, these rules, the application of these to Ms. Azad's case in Mirza,
Asan, Miss Asan,
Azan.
case, yeah.
how would they impact that case? Were these were the rules applicable at that time, are they?
No. So these were the rules as amended after Mirza to give the additional flexibility that Lord Carnwath, said it was very unfortunate was not provided for at the time. He was dealing with it in terms of payment of the fee rather than any of the other requirements within 1 to 9. But I think there was simply no provision there for people to be given an opportunity to correct an error.
And did the rules at the time say that the application is invalid?
The rules at the time for our
Of
purposes,
Mirza?
both, yes, I think so. I will double check and I'll come back if they didn't, but I think both the rules at the time of Mirza and the rules at the time of these cases both said is invalid.
Valid.
Yes.
That didn't prevent Ms. Azad's case.
Miss Asan's case.
Asan's,
No,
sorry,
sorry.
I do apologise.
There are too many names, I go.
From the Supreme Court holding that there was a power to treat as opposed to being invalid.
Well, it was a bit different in her case because this court held that there wasn't an initial requirement, that she was, I am going to go to Mirza because it is quite complex factually, but in her case, Justice Carnwath said she didn't initially have any requirement to pay, to go and enrol her biometrics. She was notified of that some months later by the Secretary of State, so her application wasn't initially invalid. And although the appellants, who were represented by the same counsel, hadn't sought to draw a distinction between any of the cases, he said, I think there is an important difference because her application was not initially invalid. It only became invalid when the requirement was imposed and she failed to comply. So it's not quite on all fours with this case, but it certainly wasn't on all fours with the non-payment of the fee cases. I don't know if that helps.
Well, I just have difficulty in seeing how this case, the application was initially valid because there was an application for exemption. And so why isn't it all fours? Well,
because I will go to Iqbal and Mirza, because in this case the order says that if somebody doesn't pay, the Secretary of State must treat the application as invalid, whereas Lord Carnwath, not having been taken, I suppose because it wasn't argued that way, to subparagraph 3, didn't appreciate that there was a mandatory provision. He just looked at the 4 alternatives and said, well, until the Secretary of State's decided which one of those 4 options she's going to choose, the application isn't invalid. The invalidity is contingent on a positive decision by the Secretary of State. I hope it'll become clearer when we turn to it in a moment. Yes. We have sent in the rules at the time of Mercer, and you'll see the 34C.
Sorry, where are we getting these
We've
from?
got,
It was sent through this morning.
we've been receiving
I'm so
versions
sorry.
of the rules thick and fast from both parties. It may take us a moment to identify them.
So the immigration rules, what date is it?
March 2013, did you say?
Yes.
March 2013.
Yes.
Okay, that's first email.
March, yes.
It's page 38 of the PDF that was, when was it sent through? Another time. I'm afraid this is one of the reasons why I thought I'd take the 276B point first. I thought it might take me through to lunchtime and that we could make sure you had all the papers in the right place over the short adjournment. I'm sorry.
Don't worry.
It was sent at 10:30 this morning.
So, on page 38, you say?
Page 38 of the PDF.
It's page 38 of the PDF.
Yep.
And the only point I was going to make about it, it'll become more relevant when we turn to look at Mercer, was that 34C, even at that time, provided for notice of invalidity to be given in writing.
Mm-hmm. So this is the rule that Lord Carnwath was referring to in relation to the first three cases in Mercer.
Yes.
Yeah.
And the point I'm going to be making in a moment when we come to Mercer was that he plainly didn't regard the notice as constitutive because...
I thought he was referring to the regulations rather than to the rules. I thought it was paragraph 37 of the 2011 regulations rather than the rules.
Probably in that case as well as in this, you had to look at both.
Yeah.
Here we've got an order and the rules, and there you had a regulation and the rules. But I think my learned friend relies upon the rules, which in both cases make provision for a notice of invalidity to be sent. And he says, well, look at the rule. The rule provides for a notice of invalidity to be sent. That is constitutive. It's only when that notice is received that an application is invalid. And we say, no, it's informative. It is telling the individual applicant of the position. But the onus has been on them to make a valid application. Could I turn then to the order, and then I will go to Mirza. I hope it'll become clearer then. If it doesn't, it's entirely my fault. Even if it's clear, it won't necessarily mean you agree with me, obviously, but I hope that our case will be a little clearer. So, if we look at the order, it starts at page 727. At 3, we see the requirement to pay a health charge. 1, a person who applies for, we can ignore A, B, leave to remain in the United Kingdom for a limited period must pay a charge to the Secretary of State subject to Article 7. 4 deals with the amount of the charge. 5, when a charge must be paid. 5.1, a person required by Article 3 to pay a charge must pay the amount required when the person applies for entry clearance or leave to remain as applicable. 6.1, where a person required by Article 3 to pay a charge fails to pay the required amount in accordance with Article 5 and the entry clearance or leave to remain as applicable has not yet been granted or refused, subject to subparagraph 2, and then again we go down to B, the person must pay the outstanding charge, we go down to 2, in the case of an application for leave to remain within 10 working days, beginning with the date when the request for payment under subparagraph A is sent in writing, or made by telephone or in person. As I think was pointed out yesterday, it's the date that the request is sent rather than received. And then at C, if the outstanding charge is not paid within the time period mentioned in ... to subparagraph B2, the application for leave to remain must be treated as invalid by the Secretary of State. And again, I say that's not must be invalidated, but must be treated as invalid. And the plain words would suggest it's to be treated as invalid from the expiry of the 10 days. There is no necessary inconsistency, we would say, between that and the provisions of the rules we've just been looking at, which allow for an opportunity to correct the error within 10 working days of the date on which the notification was sent. And where an applicant doesn't comply with 34B2, the application is invalid and will not be considered. So that's the language of the rules. Paragraph 7 provides for...
Yeah, sorry, the question was in relation to the statements in the rules that the Secretary of State had a discretion. Sorry.
Let me go back to that. The discretion to treat an invalid application as valid.
That's it. Sorry, I haven't got the page number.
Yeah, it's page 755,
Yes,
34B4.
You said you were just going to help us with that.
Yeah, well, I say that this is dealing with all of the requirements under the rules. It's not specific to non-payment of the health surcharge. The order, which is specific to the health charge, and of course is legislation and so prevails, says that when the charge isn't paid within the 10 days, the application for leave to remain must be treated as invalid. That's not inconsistent with the Secretary of State having discretion to treat an invalid application as valid up to that point. So, just looking at a practical example, a person, we look at the beginning words of 6.1, where a person required by Article 3 to pay a charge fails to pay the required amount in accordance with Article 5, the Secretary of State may request that the person pays the outstanding charge. She may choose not to request that the outstanding charge be paid. She may exercise her discretion instead to treat the application as valid. And that's consistent with the rules that we've just looked at, and also with paragraph 8 of the order, because the Secretary of State, as we've seen, has discretion to reduce, waive or refund all or part of a charge. So somebody is required to pay the surcharge. They don't qualify for an exemption. The Secretary of State has got two options at that point. She can exercise discretion and, using the language of the rules, treat the invalid application as valid, or using the language of the order, which should prevail because it's legislation, she could waive the charge. So it's not meaningless. 8 is not meaningless, but it only operates until that point. Because if she decides to request and the person fails to pay within the 10-day period, she then must treat it as invalid.
Why couldn't she exercise her discretion at that stage?
Because there's a mandatory provision in the legislation requiring her to treat it as invalid at that point.
Why send two letters, one in October and one in November?
Well, yes. As I've said, the rules and the order don't provide for that.
Yeah.
And
how about a dependent then? Of an applicant who, does the Secretary of State have a separate obligation to consider the circumstances of the dependent in exercising a discretion without necessarily that dependent making a formal application?
yeah, I think probably what's envisaged here is that there would be a request that the Secretary of State exercises discretion, and that request would say, I have got a sick child, or whatever the circumstances are. This is not what happened in the present case, because there wasn't a request for discretion to be exercised. There was an application to waive the fee, which was treated as an application for exemption from the charge.
I was looking at it slightly on a broader basis. Sometimes, unfortunately, children requests aren't made by parents on behalf of children. And I was just wondering what you thought the Secretary of State's obligations were.
Yeah, I mean, there's a distinction, isn't there, between obligations and powers. It's very difficult to answer that question without the concrete facts of a specific case. In the absence of any representations, the Secretary of State must obviously have regard to all material factors when she's deciding whether to exercise her discretion or to issue the request for payment. And that'll be all the factors that she is aware of or deemed to be aware of that go to whether the discretion should be exercised.
You can have the most through other parent who doesn't pay.
So sorry,
You can have a most through other parent who does not pay at an appropriate time to the disadvantage of a dependent. And I was just wondering how the discretion comes into play then.
Yes. As I said, I think it comes into play at that primary stage. But of course, it would have to be considered throughout, because if you look at the effects of this, the effect is that the person doesn't have leave at that time. It doesn't stop the Secretary of State considering any other applications for leave on different bases. I mean, this could be an application for leave to rent. I referred to a couple of paragraphs in Hock where Lord Justice Underhill sort of set out the circumstances in which such applications are commonly made. And he explained that very often people come to the UK as students, they get leave as students, they then would apply for post-study leave, and they'll get an additional period for that. They then might apply for leave to remain on the basis of, for example, family life. So if they don't make their application validly within the rules, there is no valid application under the rules, but the Secretary of State, of course, always has an obligation to comply with her duties under the Human Rights Act. And so if at some subsequent stage the applicant put forward a case that they shouldn't be removed because of the impact on the child, that would have to be considered. But I think it's not something that explicitly comes into play here.
I mean, presumably the Secretary of State can always grant leave outside the rules. I mean, that happens quite a lot.
Yeah. And not infrequently representations are made by people who say, I accept I don't strictly fall within the provisions of the rules, but there are exceptional circumstances. But these rules aren't really looking at that. These are rules about what constitutes a valid application, when we look at the immigration rules, and what is the requirement to pay the health surcharge if you're looking at the order. So that's my answer to how 8 fits in with the rest of the rules, that it's a discretion, a general discretion, but it's overcome by the mandatory requirement in 6(1)(c) in the very specific circumstances provided for there. So once the various stages have been gone through, the Secretary of State has, by implication, decided not to exercise discretion, but rather to require or request that the outstanding charge be paid. So looked at in that way, there is, we say, no necessary inconsistency between the rules and the order. They can be interpreted and applied consistently with each other. None of them provide that the application will only be invalid once notification is received.
Just on the interaction between Article 6 and Article 8, Article 6(1) begins by talking about a person who fails to pay the required amount. So is it your submission that at any point up to the inception of the mandatory obligation under Article 61C, if there's a reduction or a waiver under Article 8, that's not a required amount and therefore doesn't need to be paid under
Yes.
Article 6.
Yes. And if I'm wrong on that, my fallback submission is that even if the discretion extends after service of the request and non-compliance, discretion wasn't exercised on the facts of Mr. Afzal's case, and indeed there wasn't a request for an exercise of discretion. And the case isn't put against me on the basis that the Secretary of State acted unlawfully in not exercising discretion. That's not the issue before my lords. What's said is, on the plain words operation of the rules and the order, the application for variation is valid until notice of invalidity is received. And
I'm wondering if the fallback position may be the stronger one. 6.1 begins, where a person required by Article 3 to pay a charge fails to pay. Now, Article 3 requires a person who applies for entry clearance or leave to remain must pay a charge subject to Article 7. So that's the exemption provision. So far as Article 3 is concerned, Article 8 doesn't affect who is a person required to pay a charge in terms of Article 3.
no.
And he's required by Article 6 to, Article 6 applies where a person required by Article 3 to pay fails to pay in accordance with Article 5, and Article 5 requires him to pay the amount when he makes his application.
Yes.
So, read short, Article 6 is saying where somebody has failed to pay the required amount at the time of his application, then under A, the Secretary of State may request, but I suppose an alternative would be to grant a waiver under Article 8.
Exercise discretion under Article 8. Yes, exactly. Because that is a power, may request, not must request.
Yes.
So she has the alternatives at that point, may request or may waive or reduce under Article 8.
And so in the way Article 6 operates, in principle, if the request is made for payment of the outstanding charge, and then there's then a failure to pay it, then there's then an obligation on the Secretary of State to treat the application as invalid.
Yes. Yeah. So I say naturally the discretion would fall to be exercised at the point that decision's made. You either request or you might waive. It's not that you don't exercise the discretion, you don't consider it, but that's the point at which it's done.
I mean, the heading to 6.1 also seems is conditional on the entry clearance or leave to remain has not yet been granted or refused. Mm-hmm. So does that mean that the Secretary of State could choose just to treat it as an invalid application because of non-compliance with those initial requirements? And would that then be the leave to remain is refused?
Yeah. No, that would be the application is rejected as invalid.
Right, so that is a different concept.
Sorry, let me just check. No, you're absolutely right, my lord. I'm so sorry. Leave to remain may have been granted or refused. So she may have considered the application substantively.
But she may, what I'm asking is, the word refuse there, would that cover a situation where the Secretary of State sees that the requirements in Article 3 and Article 5 have not been complied with, so on its face, a non-compliant application,
Yes.
Which, according to the rules, is invalid, subject to any exercise of discretion in relation to it. So, does that heading give the Secretary of State, in effect, the option simply to refuse the application as being invalid for non-compliance with the requirements in Article 3 and Article 5?
Yeah.
That's what I'm asking for help with, because you've said that it's just a discretion may request, but then if one looks at 61C and B and C, the time limits are given by reference to the making of that request.
Yes. So I think she's only obliged to treat the application as invalid if she makes the request and it's not complied with in the time limit specified. Okay.
Right.
Right. But she may not have made the request and just decided to refuse the application or indeed to reject it as invalid. For somebody, let's say, for example, someone hasn't applied for a waiver, hasn't suggested that they're eligible for an exemption. The Secretary of State could, on the face of the rule, not exercise her discretion to, Melanie referred to it as a reminder, to send a reminder in the language of the order, to send a request. As a matter of law, that would be an option open to her, but I suspect there'd be quite a high prospect that she would be sent a pre-action protocol letter saying, why didn't you exercise your discretion in my favour? The rules provide for you to send me this request, and she'd have to have a reason for doing that, for not sending the request and simply proceeding to treat it as invalid, or indeed to treat it as valid and refuse it.
All right, thank you.
I think I'll be told if I'm wrong on that. I'm looking around I'm getting nods, so I think that's right, but I will be told, I'm sure, during the short adjournment. I hadn't thought about that specific point, my Lord, and if my submission was inaccurate, I will endeavour to correct it after the short adjournment. So I entirely accept that the order and the rules are not the clearest, but I say that they can be interpreted consistently with each other, and that the one thing they are clear about is that it's not notification that is constitutive, it's the failure on the part of the applicant to make the application valid. So should we turn then to Mirza, also sometimes referred to as Iqbal, to see how this court dealt with those cases. So the report starts at page 982. I was going to pick it up at 985, just to note that paragraphs 1 and 2, this was also a case about 3C, how 3C operated, where applications for further leave were procedurally defective for some reason, as Lord Carnworth puts it at paragraph 1. I thought it might be easier if I dealt first of all with the first three appellants, so I'm going to ignore for the moment the paragraphs dealing with Miss Asan, and I will come back to looking at those in a moment.
It's perhaps worth, I don't know how much of the procedure and legislation we need to look at, but my eye was caught by paragraph 4, where we see what the state was of the immigration rules at the time.
Yes.
And there may be other aspects of the legislation at the time that we need to be aware of.
Yes. So 34C in particular which you have at, I think you have 34A at page 755, para 14, but that's the rules in force at the time of Mr. Afzal's case. The rules in force at the time of the Iqbal Mirza cases are the ones we emailed through at 10:30 this morning, because we realised they weren't in the bundle and we thought you might be interested to see the rules that this court was considering in those cases.
Yeah, and so the rule 34C, this predates the 34. I take it this predates the 34B flexibility.
Yes, I'm pretty sure.
What we have in the current rules.
Yes, that's right.
Or at least the rules we're looking at for the purposes of this case.
Yeah, and sorry, I don't have them in front of me because they were emailed through as I was coming through to court, and I'm worried about crashing my laptop, so I'm going to ask Mr. Keith if I can look at his. So what we drew attention to was 34, the second part of 34C, which isn't cited here by the court at paragraph 4, but it's at page 38 of the PDF.
Mm-hmm.
And the point I make in that regard is that even then, the rules provided for notice of invalidity to be given. And if my learned friend was right, that notice of invalidity is constitutive rather than informative, one would have expected that to be the case in Mirza, because it was a requirement that you send that notice even then.
And then, as Lord Stevens pointed out earlier, they have at paragraph 5 we see the relevant regulations addressing the consequences of failure to pay a fee.
Yes. Yeah.
Did 34C apply to fees for biometric data? No?
I'm trying to leave 34C, the biometrics case, to come to it afterwards. But yes, I think 34C, as I read it, is a general provision.
Yeah. So it would, if you didn't pay your fee and were required to pay the fee at the start, it was to be treated as invalid. Will be invalid.
Yeah, if it doesn't comply with the requirements in 34A, it will be invalid and will not be considered. And the requirements in 34A, if we can just scroll up, I think include the fee, which was the non-compliance in the first 3 appeals. They hadn't paid the fee. Yeah, it's 34A2. Any specified fee in connection with the application or claim must be paid in accordance with the method specified in the application form, payment form, guidance notes.
And that would include the
it's the bottom of page 36 of the PDF.
And that would include the biometric fee.
Oh, my Lord, I'm so sorry. I'm going to have to deal with biometrics separately, if you don't mind, because otherwise I'm just going to confuse myself totally. It's my fault. Would you mind very much bearing with me and just letting me deal with the first 3 appeals, and then I'll come to the biometrics. So
just before we leave 34C in the 2013 version,
yep.
As I'm understanding it, the point you're making is about the notice of invalidity is the same as the one that you made on the rules before us, that the rules say it's invalid. So when one's looking at notice of invalidity, as I understand your submission, that can't be constitutive because the rules have already prescribed what the effect of invalidity should be.
Yes, precisely. And that's the approach that Lord Kharmouth adopted in Iqbal and Mirza. And I will come to Miss Ahsan, who he considered was in a separate category, in a moment. So at paragraphs, bottom of page 987, and on to paragraph 11 at 988, he deals with the facts of the Iqbal and Mirza cases. And they were both applications for further leave where the correct fee wasn't paid. As we've seen, that was a requirement under 34A. So, what was the analysis? What was the effect of that non-payment of the fee was the key issue. And at paragraph 14 on page 989, Lord Carnwath explained how the nature of the issues and the positions of the parties had shifted markedly, he said, during the progress of the cases. So in the Court of Appeal, departing from the position taken before the upper tribunal, the claimants, through counsel, contended that an application which was invalid under the regulations was still effective to engage the automatic extension provisions, by which he means 3C, the automatic extension of leave. The Secretary of State at that stage did not contend otherwise, even though that represented a change from her previous position in other cases. And her argument at that stage was effectively the same as the argument Mr. Jafferty puts forward now. You see that from the end of paragraph 14. As Lord Justice Elias explained in paragraph 22, she now relied on the next stage. That is, the effect of the Secretary of State's notice rejecting such an application as invalid, which she submitted, should be treated as a decision on the application, thereby bringing the leave to an end under 3C2A. And then at 15, you'll see the Secretary of State, by the time the matter came to this court, had reverted to her previous position, which is that the applications were not valid. And Mr. Jafferty took you yesterday to the policy reasons for the approach the Secretary of State had adopted in the Court of Appeal. And I will address those in a moment. My answer to those briefly is that this court said, yes, it was very undesirable that there was so little flexibility, and that led to the introduction of 34B, and the Secretary of State now has power to give people an opportunity to make good any failing. Anyway, just looking at the reasoning, if we turn over leave to 990, paragraph 16, this approach, namely the approach of treating the notification of invalidity as bringing leave to an end, or treating it as valid ab initio, so valid until such notification, led in turn to the need to find some means of bringing the extended leave to an end. Otherwise, as Lord Justice Elias pointed out, it would be possible for someone with limited leave to submit a defective application and thereby secure an extension of time which would become in effect indefinite because no valid decision could be made bringing it to an end. It was for this reason the Secretary of State was constrained to argue that the rejection of the application as invalid could itself be treated as a decision on the application for that purpose, so for the purpose of 3C. So the Secretary of State was saying it's a valid application and I decide it within the meaning of 3C and I bring it to an end by the notification of invalidity. It might help just to turn back quickly to 3C, which is set out in the judgment helpfully. It's on page 986. At the bottom of 985, the court says 3C at the material time read as follows. Materially, it's the same for the purposes of Mr. Afzal's case. The section applies if a person who has limited leave to enter applies for a variation. The leave expires without the application for variation having been decided. And then 2, the leave is extended by virtue of this section during any period when the application for variation is neither decided nor withdrawn. So the Secretary of State was arguing that it had been an application, but her rejection of it by notification of invalidity amounted to a decision on the application.
My understanding is that the Secretary of State now relies upon the 2A, presupposing that there is an application, because you have the same problem. That is, when does the extension come to an end? And you say the extension comes to an end because it presupposes 3C2A, that there is an existing application, a valid application, and therefore that's the end of the extension.
Yes, I say that 3C1 applies if a person who has limited leave to enter or remain applies, and the application is made before leave expires, and the leave expires without the application for variation being decided. It's implicit in that there is a valid application in existence to be decided.
It's a slight variation on your written case, but...
oh, I'm sorry.
Well, no, I'd taken you as to be relying on 3C2A.
I would rely on it as a fallback if I need to, but I think my primary position is that the Court of Appeal was correct in saying that 3C leave came to an end at the point where there was no longer a valid application. It's all premised on the existence of a valid application throughout.
So that's not determinative of the difference between the Secretary of State and the appellant, because the appellant doesn't have to rely upon the application being decided. The appellant can also rely upon there being some positive act which brings the Secretary of State treating it as invalid. And as soon as the Secretary of State has done so, there is no valid application.
That's my case, but I think the appellant's case, I may have misunderstood it, but if I've understood it correctly, the appellant's case is what the Secretary of State's case was in Iqbal and Mirza in the Court of Appeal. He says the notification of invalidity is a decision within the meaning of 3C2, and that's what brings it to an end. There has to be a notification of decision.
Well, when I asked yesterday, the decision was identified as being a decision to treat it as invalid,
yes,
as opposed to a decision determining the application.
That's absolutely right.
Yeah.
He says decision is wide enough to encompass both of those.
Got it.
And I say that the Court of Appeal was right in Mirza and Iqbal to say, as recorded at paragraph 17 of Lord Carnworth, that was wholly unsustainable. He rejected as wholly unsustainable the Secretary of State's argument that notification of invalidity could constitute a relevant decision for the purposes of Section 3C, since the context clearly required a determination of the application, not its rejection or a decision that there is no valid application. And we don't need to look at 18, I don't think, which is all about the fairness of the procedure in Mr. Iqbal's case, but we should look at 19. So in this court, counsel for the appellants renews the argument that the word application in 3C is unqualified by reference to any procedural requirements in subsequent regulations and should not be interpreted by reference to them. He points, as indeed do the appellants here, to the strong policy arguments of that interpretation. Overstaying as a criminal offence may result in a penalty for the employer, etc. He does not shrink, by letter H, he does not shrink from the possible consequence that leave may be extended indefinitely, but submits that the answer is in the hands of the Secretary of State by appropriate amendments to the regulations or, if necessary, to Section 3C itself. So having summarised the shifting positions of the parties and the arguments, on the next page at 991, the court set out the legislative history. I wasn't proposing to read it all, although the court may find it informative. I was going to move on, for my purposes, to the discussion at paragraph 30, and simply draw your attention to, at 31 in particular, this is the section where Lord Carnworth says, just underneath letter D, surely a need to introduce some measure of flexibility to ensure that bona fide applicants were not unduly penalised for simple mistakes which could be readily corrected. There have been some examples of flexibility, been given no explanation for the more rigid approach adopted in respect to fees, and we've seen that's now been put right, and that's the provision for the one opportunity to make good the error, which has in turn really led to us being here, because what is the consequence for that on when an application is invalid? And that's what we've been looking at, the rules and the order to see. We turn over to 994. Lord Carnworth says we must accordingly decide the present appeals within the legislation as it stands. The issues have to be approached by the application of the ordinary principles of statutory interpretation. They start from the natural meaning of the words in their context. On that basis, I have no doubt that at least in respect of Mr. Iqbal and Mr. Mirza, the Court of Appeal reached the correct conclusion. There is no ambiguity in the words of Regulation 37 of 2011 regulations. It provides in terms that if an application is not accompanied by the specified fee, the application is not validly made. In ordinary language, an application which is not validly made can have no substantive effect. So even though the rules at that time provided that the Secretary of State was to serve notification of invalidity in these cases, that's cases where a fee wasn't paid, it wasn't notification of the invalidity which was constitutive. It was the fact that there was no valid application.
So that's happening automatically?
Operation of law, as the Court of Appeal put it in Afzal. And that's fatal in my submission to my learned friend's argument that Anna Frieva, the principle that a public law decision has no effect until it's communicated, it has no application here because we're looking at a scheme where it's not. Anna Frieva was concerned with an application which had been made, but no notice of decision had been sent. Some of the court may remember the facts, but it was somebody who had applied for asylum, and the regulations, social security regulations, provided they became ineligible for certain benefits once the application had been refused. Mrs. Anna Frieva hadn't received any notice of refusal, but her benefits had been stopped. And the court said, well, fairness requires that she be told that her application had been refused, and that the decision couldn't be operative until she'd been given notice of it. But this is a self-contained scheme. The onus is on the applicant to make a valid application. And they're in a position to know whether or not they've done so by looking at the forms and the guidance. But all the more so now, where there has been the flexibility that Lord Carnworth called for, and which was exercised in Mr. Afzal's case by sending a request for payment. So you look at the statutory scheme. Now I will turn to Mrs. Ahsan's case, if I may, and explain why that was different. So we're still on page 994, and in paragraph 36, Lord Carnworth turns to Miss Ahsan's case, and he says that counsel for the appellant didn't rely, as the court understood matters, on any material distinction between the applicable provisions, but the court considered, Lord Carnworth giving the judgment to the court, that there's a potentially important difference. The obligation to pay the fee arises at the time of the application. There's no conceptual difficulty in providing that an application unaccompanied by a fee is invalid from the outset. The requirement to apply for biometric information arises only at a later stage on receipt of a notice from the Secretary of State. Can I pause there to say that's slightly different, because in the case of the immigration health charges, we've seen there is a requirement to pay with the application. I continue. Thus, in Ms. Asan's case, the application was made in December 2011, but it wasn't until the following February that she was required to make an appointment. Even then, it was accepted that there might be a reasonable explanation justifying further delay. It's difficult to see any reason why a failure at that stage should be treated as retrospectively invalidating the application from the outset, so nullifying the previous extension under 3C of her leave to remain. Appears to be nothing in Section 7 of the 2007 Act to support such retrospective effect. The revised version of Regulation 23(2)B, which was in force at the time of the decision to reject her application as invalid, does no more than give the Secretary of State power to treat the application as invalid. There might be some question as to how that wording relates to terms of Section 7.2, but as I've said, there was no challenge to its validity. In any event, there is no reason to read it as having retrospective effect. The natural reading, which is consistent with the statutory purpose, is to give power to invalidate the decision as from the time of the decision, but not before. Now, that's not time when notification of the decision is received. It's power to invalidate the application as from the time of the decision. And we have to look back to what the decision was, as Lord Carnwath understood it to be. And we see that at page 987, paragraph 7, just below letter E, Regulation 23 provided that on failure to comply, the Secretary of State may, in inverted commas, take any of the actions specified in paragraph 2. The actions specified are to A. Refuse the application for the biometric immigration document, B. Disregard the person's application for leave to remain, C. Refuse the person's application for leave to remain, and D. Cancel or vary leave to enter or remain. Regulation 23 was amended from 29th of February 2012 by Regulation 10 of the 2012 regulations to substitute for 2B the following: treat the person's application for leave to remain as invalid. Now, as Mr. Jaffe has quite correctly pointed out, if the court had gone on to read further into the regulation, there was a provision saying the Secretary of State must treat as invalid in the circumstances applicable to Ms. Asan. And it looks to me, with the greatest respect, that the court wasn't enormously assisted by the fact that that was not the case being advanced by any of the parties. The counsel for the appellant wasn't drawing a distinction in Mrs. Asan's case. So it looks as if the court wasn't taken to the mandatory provision and proceeded on the basis that on failure to comply, the Secretary of State may take any one of 4 actions. And it's the decision as to which of those actions to take that invalidated the application.
But it does fall within the mandatory requirement.
I think so, yes. I've tried to check, and I can't see any reason why it wouldn't have done. It's just that, unfortunately, Lord Carnwath wasn't made aware of the mandatory requirement and proceeded on the basis that the State may take any one of 4 actions.
So what do you suggest we do about the decision?
Well, fortunately, I think all those regulations have now been overtaken by numerous amendments. Really, the question is, what light does that shed on the approach in the present case? And that was something the Court of Appeal in Afzal looked at with considerable care. So at this point, maybe it would be helpful to turn to that decision again, which, as we've seen, starts at page 66. And this part of the reasoning starts at page 75.
So just before we leave Mirza, I mean, I was looking again at paragraph 36. So it's Lord Carnworth drawing a distinction between the first two cases and Ms. Asan's case based on the discretion that the Secretary of State has to exercise.
Yes.
And saying, well, because there's a discretion, the cases are different. I mean, one might think that the logic of his reasoning in the first part is if he'd appreciated that Ms. Asan's case was a Regulation 23.3 case, and therefore invalid from the outset as well, it would have been assimilated with the first two cases.
Yeah, except that he also considered that there hadn't initially been a requirement, if you recall, we just looked at that a moment ago. So he said the requirement only arose when the Secretary of State requested her or required her to go and register her biometrics.
Yes.
Just go back to that bit. So there were two distinctions. There wasn't an initial requirement.
But in a sense, the two run together, in the sense that he thinks that there isn't an initial requirement, and so someone has to ask for it, the Secretary of State has to ask for it, and then the Secretary of State has a discretion what to do when it's not provided. So
there's four options. Yeah.
All right, thank you.
Yes. Whereas we know that on the facts of Ms. Asan's case, actually there was only one option. The Secretary of State had to treat it as invalid when she didn't go and enrol her biometrics. But that's only because we have looked at read on down the regulation.
Yes, I was just looking at the third sentence in paragraph 36 on page 994. Lord Carnworth says, there is no conceptual difficulty in providing that an application unaccompanied by a fee is invalid from the outset. So, are you saying that under the relevant regulations, biometric regulations at the time, the application unaccompanied by the biometric information was invalid from the outset?
I don't think it was, and I certainly don't think Lord Carnworth thought it was, because he goes on at the next sentence to say, the requirement to apply for biometric information arises only at a later stage, on receipt of a notice from the Secretary of State. So the fee had to be paid with the application form, but as he understood it anyway, the requirement for biometric information only arose once a notice had been served.
He gives an account of the facts of paragraph 12.
Yep.
We'll see that she made an application for leave on the 23rd of December 2011, and the Secretary of State thereafter wrote requesting her to make an appointment to provide biometric information. And it was she was then warned that unless she did, her application would be rejected as invalid.
Yes.
And then in March 2012, she was told it was being returned as invalid.
Yeah.
But in your case, the decision at paragraph 37 is wrong. Because it was compulsory. It was mandatory. It wasn't retrospective, but as from the date that she failed to comply, it was invalid.
Well, yes, except that. I mean, I say that I accept Mr. Jaffergy's point that if you read on, it's clear that there weren't the four options that Lord Carnworth thought, but he seems to have proceeded on the basis that there were four options.
Yeah. Knowing what we now know, that is the next provision down, 23.3.
Yeah.
Is it your case that that application should have been treated as invalid?
Yes.
Yeah.
Yeah.
And as from what point?
As from the point where she didn't comply with the requirement.
Yes, so you applying the reason in the present case, she was told to attend an appointment within 17 days of the letter of the 24th of February, and so you would say that 17 days after the 24th of February, having failed to do so, her application then became invalid.
Yes. Yes, because the four options relate to a wider class of cases. The must treat as invalid did apply to her circumstances, but the court doesn't seem to have read on to 23.3.
So it's my fault. I'm still just trying to see how the biometric regulations worked at the time in Ms. Isan's case. According to the proper approach under the regulations, was it a requirement when she made her application that she provide her biometric information with the application in order for it to be valid?
Well, Lord Carnwath didn't think it was.
I'm not asking about Lord Carnwath, I'm just asking about...
I will look at the biometric regulations again.
I mean, we can find the answer by looking them up as they stood at the time of her application, I suppose. So,
all right.
So I think she did, if you look at page 5 of the PDF which my learned friend sent through.
Is that the biometric regulations of 2008?
Yes.
Page 5. And sorry, what?
Actually, it's not very clear. I'm so sorry not to be more helpful.
Well, look, let's not take up time on it now,
Okay.
but if certainly I would be assisted just to understand what the true position was.
Yes.
Fully. I appreciate Lord Carnwath overlooked Regulation 23.3.
Yep.
But it would give me some confidence anyway if I could understand exactly how it was.
Yes, I'm so sorry.
No, that's fine.
I hope I can just clarify this over lunch, but I think it's Regulation 3 on PDF page 5, requirement to apply for a biometric immigration document. Subject to paragraph 6, a person subject to immigration control must apply for the issue of a biometric immigration document where he satisfies in the condition in paragraph 2. The condition in paragraph 2 is, the condition is that whilst in the United Kingdom, the person makes an application for limited leave to remain for a period which, together with any preceding period of leave to enter or remain, exceeds a cumulative total of 6 months leave in the United King. And Ms. Asan would have fallen within that.
It also brings me back to my question about 34C and whether the fee for the biometric material also has to be paid at the same time as the application form
Yes.
under 34C.
That's exactly what I was going to sort of turn to next. What Regulation 3 doesn't do is say when they're required to do it.
Well, I would just... Whereabouts in the biometric regulations do we have the requirement to pay the fee? And I'm sorry for asking these questions.
No, my lord, I'm so sorry not to have the answer at my fingertips. But I think in her case, it wasn't non-payment of the fee that was the issue. In Miss Asan's case, it was the non-attendance at an appointment to enrol her biometrics.
Yes.
And we see that. I'm afraid the facts just are not very fully set out in Iqbal and Mirza. At 5.1...
Sorry, what are you referring to now? 5.1?
Sorry, of the biometric regulations 2008.
Yes, thank you.
Subject to Regulation 7, where a person makes an application for the issue of a biometric immigration document in accordance with Regulation 3, an authorised person may require him to provide a record of his fingerprints and a photograph of his face. That's what people get an appointment for, and she was given an appointment that she didn't turn up to. So that was where there was the breach.
So does it work this way, that when you make your application, I mean, I was looking at 3.2e, it talks about an application for indefinite leave to remain, or sorry, perhaps that wasn't an issue in that case, but A, you say was.
Yeah.
You have to, in effect, tender yourself as being ready to attend an interview. So is that the way it works? That you make clear in your application, I'm ready to attend for
Yes.
to provide biometric information.
Yes.
You're then given an interview, and you have to turn up for that interview. Is that the way it works?
Now, I didn't do anything about these regulations back at that time. I have done some litigation about the biometric regulations subsequently, and I know that the position more recently has been that the application for leave includes an application for a biometric residence permit. It's one and the same thing. The application for leave includes within it the application. The people will then either be required, and they will normally be required, to attend to enrol their biometrics, i.e. the fingerprints and photograph, etc., or they won't, and in most cases they will be required to. And there's been litigation about this in the context of Afghanistan quite recently, where applicants have been saying, well, we can't attend an appointment because there's no longer a high commission or consulate in Afghanistan since the Taliban took over. So there's been some litigation about this relatively recently. So I know that the recent position is the form automatically includes within itself the application for a biometric document. The requirement then is that you attend an appointment. I think Mr. Keith may have done this more than me, I think he's nodding. And what's fairly plain from ASAN is that what Miss ASAN failed to do was attend the appointment.
So am I understanding that the upshot of this is that if we treat the ASAN part of the decision in Mirza as dealing incorrectly with the provisions, should have dealt with subsection 3 instead of subsection 2, the case becomes on all fours with our case, and that therefore your submission in relation to it would be that whatever the condition was that subsequently failed, at that point there is an invalid application, and that therefore, just as you would say, that invalidity is in your favour in our case, so it would mean that the ASAM part of that decision should have been decided differently.
Yes, I'm afraid so.
Yeah.
And I'm so sorry, because, I mean, we should have obviously notified the court if we were going to say a previous decision was incorrect, but it wasn't until we were provided with all the various regulations and the biometric regulations.
Well, it's an unusual situation. You're not quarrelling with the reasoning, really, on the basis on which the court approached it, but you're saying it's effectively per incuriam, and that they weren't properly informed about the background. But when Lord Carnwath, I mean, the only relevant application he mentions, I mean, he proceeds on the basis in paragraph 12 that Ms. Asan made an application for further leave to remain as a Tier 4 student. And the Secretary of State then wrote requesting her to make an appointment to provide biometric information. Now, I don't know if I'm right about this, but must she, in fact, have made an application under the biometric regulations?
Yes, that's what she was required to do if you look at the regulations together with the facts. So if you read on, by letter dated 24th of February, she was told that unless she booked and attended an appointment within 17 days or provided a reasonable explanation for her failure to do so, her application would be rejected as invalid. So she seems to have, I mean, this seems to accord with the way the regulations operate now. Her application form included an application for biometrics, and she was told she had to make an appointment to provide her biometric information.
Yeah, so actually she's made an application under Regulation 3 of the biometric regulations, although we're not being told that. And this request is presumably being made under Regulation 6. No, it's not. Is it 6, which is the one that...
No, 6 is where the Secretary of State already has the fingerprints and photograph. I think it's 5.
5.
So...
Yes, where a person makes an application under Regulation 3, effectively. an authorised person may require and provide a record of his fingerprints and photograph of his face.
Yeah, and that's what the appointment would have been for.
Yes. Yeah.
Regulation 8 is also relevant, I think. If you look at 8.2, an authorised person may, A, require a person to make an appointment before a specified date, which the person must attend, to enable a record of his fingerprints or a photograph of his face to be taken. So that's the power to require someone to attend an appointment.
And is there a provision in the regulations about the consequences of failing to comply?
That's just what I'm looking for. Yes, Regulation 23.
Oh, yes, of course.
Yeah.
Yes.
So we've got the right starting point and the right end point, apart from not reading on to 23.3. So when somebody doesn't comply with the requirement to attend the appointment to provide their fingerprints and the photograph, Secretary of State may take any or any combination of the 4 actions at 2. But where it's a 3.2a or b case, Secretary of State must refuse the application of a biometric immigration document and must treat the person's application for leave to remain as invalid.
And it was a Regulation 3.2a case.
I think it is. Mr. Jaffergy says it is, and I've got no reason to think he's wrong. Let me just go back to 3.2a again. Yes, we looked at 3.2a a moment ago. PDF page 5. The person makes an application, whilst in the United Kingdom, the person makes an application for limited leave to remain for a period which, together with any preceding period of leave to enter or remain, exceeds a cumulative total of 6 months' leave, which was Mrs. Hassan.
I'm sorry to complicate things for you. I'm looking
Not as sorry as I am, but...
I'm looking at... I think you might want to look at this over the short adjournment. I'm looking at the version 1 of Regulation 23, which was in force until the 28th of February 2012. And that had 23.2 conferred the 4 options, but 23.3 was not in the format that we've been looking at.
Oh, whereabouts does my lord have that?
I've brought it up on Westlaw.
I don't think it's in the papers before the court, as far as I'm aware. I mean, we've got an enormous number of papers before the court, and as you're aware, this was only provided quite late.
Will you be able to access that over the adjournment, and indeed Mr. Jaffergy as well?
The HMSO legislation only has the original, in fact.
Well, let's...
I'm very grateful to Mr. Keith, who I think may have cast light on this, and he's pointed out... Sorry, can you give me those dates again? The request was made to her on the 21st of April 2012. That's paragraph 13. So that's before those regulations.
According to paragraph...
Sorry, it's after the regulations that my lord's turned up on Westlaw.
According to paragraph 12 of Lord Carnwell's judgment, by letter dated 24 February 2012, she was told that...
You're absolutely right.
So I think we may be able to... In fact, we may have been casting aspersions undeservedly on one of my former colleagues.
Well, I'm very glad not to have to pursue that, but I'm very sorry for the fact that we didn't have the right version of the regulations.
Well, I suggest, I mean, obviously, I've just brought it up.
Well,
In fairness to me, it was the point that was being put against me that it was mandatory.
Yeah.
It seems that Lord Carnwath was right, and it wasn't, and the Secretary of State did have options.
well, the Lord Carnwath at page 995, paragraph 37, was relying upon the updated regulations. The revised version of Regulation 23(2)B, which was in force at the time of the March 2012 decision. That was the one that was relying on.
Lord is also absolutely correct. We will try to be back at 2 o'clock with a little more clarity.
Bring that up in just a moment. That's version 2. And I've got that up now. That's the version that introduces must treat as invalid.
Yes.
And it may be the fact it was so new that led to the confusion.
Well, so I think we're better adjourn now and give you an opportunity to catch your breaths and have a look at these regulations.
Yes. My lords have been really patient, and I'm terribly sorry for the confusion.
I think, given you've got to look this up, I think we could resume at 2:10.
Thank you very much indeed.